For this conversation entitled Post-Separation Abuse, we bring together a seasoned journalist and several well-known experts to discuss the nature of post-separation abuse, which will include looking at how it plays out in the family court system. The panel addresses current research, the impact of abuse on children and adult survivors, and brings forward some possible interventions. The moderator for this conversation is Jane O'Donnell. Jane is the founder and CEO of Youthcast Media Group and USA Today's former health policy reporter. Youthcast Media Group trains diverse high school students from under-resourced communities to do multimedia health and social issue journalism and gets their work published in media outlets. While at USA Today, Jane covered many beats, including health policy, mental health, childhood trauma, and patient safety. As an author, TV, and radio contributor, Jane has appeared on Good Morning America, CBS This Morning, CNN, MSNBC, NPR, and C-SPAN, and she has been published in many notable magazines.
Thank you so much, Sandy. I was, as I mentioned to you, more than happy to do this panel as a person who is a survivor in my late 20s, which was in the early 80s. I was in a violent relationship and fortunately did not have children with him. But this is a subject that's very important to me and deserves considerably more attention. I'm just going to do a quick run through for anyone who may not have read it when they signed up of what we're talking about today, and then I'm going to move as quickly as possible through the bios without, I don't want to give anyone short shrift because we got a lot out there about me. I just want to mention the importance to me of this is the effect on children. I think that's what, why we're all here. But unfortunately, in addition to whatever happens during bad marriages, and I had a doozy, like so many other women, some on this panel and elsewhere, the family court system often becomes a platform for abuse so that can continue in what are known as high conflict custody cases. It's not a father or father, more of a, it's not a father versus mother, like one side or the other is always the perpetrator. It's abusers and other unstable parents can often can continue to hurt children and survivors of domestic violence by seeking full custody of their children. I was very interested to see, it is dated research, and we're going to talk about the need for more research today. But according to the American Psychological Association, abusive parents are more likely to seek sole custody than nonviolent ones, and they are successful 70% of the time. These domestic abuse survivors are often blindsided when they see that what they believe is a betrayal in the court system that they think is there to protect them, or at least set up to protect their children. So today we're going to hear from advocates for family court reform, and they're going to discuss the precarious, bewildering nature of the family court system. And I'm looking forward personally to their insights and thoughts about the solutions. I wanted to start with Maisha Coulter. Maisha dedicated her personal life to advocate, her professional life to advocating for the results for the needs of children and families in crisis. She's always found work that allows her to draw on the strengths of her educational training in social work and the law. She is a lawyer. She attended school in New York, graduating from Syracuse University. My daughter just graduated from there. I'm a big fan. We have a student up there. And she majored she had dual bachelor's degrees in social work and public policy. After she got her master's in social work from NYU, Maisha was a licensed clinical social worker in Brooklyn, and she worked tirelessly there with children and families involved with the Child Protective Service in that state, or in that city. She received her law degree from Rutgers, and she's currently CEO of Aid to Victims of Domestic Violence, which has attorneys who provide free legal representation to survivors of domestic violence in family courts. it's a story right there that you can't get, you don't get a public defender in these cases, unlike criminal cases. Dr. Christine Marie Cocciola is also a licensed clinical social worker. She is a coercive control advocate, educator, researcher, and survivor. She's a full-time college professor teaching social work for the last 20 years in the Connecticut State College and University system. Her expertise is in not only coercive control, but the traumatic experiences of both adults and children who experience this. And she's taught workshops nationally and internationally. She's a founding member and steering committee member of the International Coercive Control Conference, and a board member of the National Coalition Against Domestic Violence. She's actively supported policy codifying coercive control, including Connecticut's Jennifer's Law, and has written several policy briefs supporting these efforts. She's creator of the Protective Parenting Program, which guides protective mothers and fathers on the journey towards healing their children. Tina Swithin she survived what she calls a Category 5 divorce hurricane while acting as her own attorney in a high conflict custody battle that turned her family's life upside down for more than a decade. And I've heard that so many times about the decade, that it can be 10 years. It's just mind-blowing, more than half of children's childhoods. She quickly learned that divorcing a narcissist or other high conflict individual escalates family law cases to levels that few can comprehend. She founded with Sandy Ross, the Family Court Awareness Month. She's the author of Divorcing a Narcissist, which is a series, and founder of the High Conflict Divorce Coach Certification Program. She's been awarded honors such as the top 20 professionals under 40 and the top 40 professionals under 40 in several regional California newspapers. She took shelter from her own family and family court storm by chronicling her journey in her now internationally recognized blog, One Mom's Battle, which is onemomsbattle.com. Katie Spearman is someone I'm very excited to have met through this venture. She's a doctoral candidate at Johns Hopkins University School of Nursing. Her research has been supported by a T32 training grant from the National Institute of Child Health and Development with lead investigator Dr. Jacqueline Campbell. Her dissertation is entitled Understanding the Impact of Post-Separation Abuse on Children's Health and Flourishing. Her broad research interests focus on the intersection of intimate partner violence and child maltreatment, intimate partner violence related homicides, the structural determinants of health and safety, such as family court judicial decision-making, and risk assessment. Her scientific inquiry is informed by clinical experience working as a pediatric nurse. Her BS and MSN are from the University of Virginia and Johns Hopkins School of Nursing, respectively. Ladies, thank you so much, all of you, for joining tonight. I'm going to start by asking Katie Spearman to kind of set us up by explaining what post-separation abuse is and how we're not just talking about mothers and abusive fathers, although that's the vast majority of these cases, and then we want to spread it around a little bit. Katie?
Okay, great. Thank you so much for that lead-off opportunity. So it's really important for us to talk about and name what post-separation abuse is. I think we live in a society where everyone thinks that if you're in an abusive relationship, then you should leave. And there aren't really as many systems responses to stop abuse that happens after that relationship has ended. And so post-separation abuse can consist of a broad range of tactics that are perpetrated by a former intimate partner. And it can include patterns of legal abuse, economic abuse, psychological abuse. This includes things like harassment and stalking, intimidation, coercion. It can also include abusive tactics that target the survivor's community. And that means her relationships with other people, her reputation, and various tactics to isolate. I've termed this like mesosystem abuse because it's harming those connections, and human beings are relational, and these connections are really important. And then I think really important that we'll talk about here more is how when children are weaponized. And that can include threatening children, putting them in dangerous situations. It can include neglect. It can also use children and co-parenting as a way to enable stalking. It also can include increased physical and sexual violence that we know, but we tend to name physical violence and sexual violence. And a lot of times these other tactics, they're not named and they're not always measured. And it's really important that we name it so that we can address it. The other thing that I want to point out is because an intimate partner, a former intimate partner, has really intimate knowledge of a survivor's personal history, what's important to them, what's important to their identity, what are their critical vulnerabilities, they really use that knowledge to exploit and target fundamental human needs of both adult and children survivors.
Tina, please weigh in. I know you have something to say, and either of you or any of you who can kind of quantify the problem, I think would be very helpful. Like, are there case counts? Is there enough data?
I would let someone else here speak to the case counts and data, but to piggyback on what Katie said, the abuser in my situation and in so many others, when you think they're interested in everything that you're saying and hanging on your every word, through the courtship, it's almost like they're creating a playbook. When Katie mentioned vulnerabilities, they're creating a playbook on how to destroy you post-separation if you were to ever make the brave decision to leave. So, so when we have survivors who are now hearing all of these stories out there and they're having to make the decision, do I just stay because what's going on in the court system and post-separation sounds worse, if you can believe that, than the abuse. It is an absolute crisis. I'll let someone else jump in and talk about actual case studies and research.
I hope we do come back to that point, because I did want to ask about that. I wonder if a lot of women might regret having made the decision to leave when it wasn't, I guess, life-threatening violence. But Katie, are you able to quantify the number of?
Sure. I mean, I can talk about what we know. So I'll start with the caveat of first, all data has its limitations. The other thing is, because there's currently no measurement for post-separation abuse, there's no measurement, so we can't really quantify the incidence and prevalence. But what I will say, in terms of what we know about childhood exposure to domestic violence, is that up to 1 in 4 children in the United States are exposed to domestic violence during their childhood. And when we look at, ACEs, adverse childhood experience, or ACEs studies, anywhere from 12.5% to 18% of children report witnessing domestic violence. And this is mostly based just on their exposure and their experiences of witnessing physical violence and its aftermath. It's not really quantifying all the other types of abuse that I mentioned. So when we talk about that, and then the overlap with parental separation and divorce, we're talking about millions of children in the United States. I mean, it's very, very common. And I think that's really important to keep in mind. And then we also know that of children who are exposed to domestic violence, 95% of them have the co-occurrence of another adverse childhood experience. And adverse childhood experiences are related in a dose response way to adverse health outcomes through the lifespan. So it's very common, it's very prevalent. And then, separation, we often talk about the adult survivors, and kids are kind of silent victims. And so it's really important for us to start to this is where I really hope research is going, is that we're starting to measure this and quantify it so that we actually have a sense of what the big scope of this problem is.
We should probably just take a quick step back, but I notice whenever I'm listening to a podcast, you need to, we can't assume that everyone understands the adverse childhood experiences, but I've thought of it as 10, but I've seen higher numbers. It's it's things like losing a parent, a divorced parent, but violence in the home. Having witnessed the violence is an adverse childhood experience, and it's quite stunning and important, and it is quantified, which is of course why it's so important for judges to look at, the link to depression, anxiety, PTSD. Christine, go ahead, and then I want to go to Maisha.
So I just wanted to elaborate a little bit on what Katie was talking about and what Tina was talking about, this idea that coercive control actually is the foundation of most domestic abuse. And what we know, so there's situational violence that occurs sometimes in relationships that's really unhealthy and can be very damaging and obviously could be deadly, but that's different than a foundational relationship that is based on coercive control, and that 90% of coercive control victims suffer post-separation abuse. We have that research that shows us that. So the incidences of having something get worse because we know the abuse intensifies, that in fact does occur in 90% of cases. And just to piggyback a little bit more is when we talk about children exposed to or witnessing domestic abuse, I really come from the perspective that shifting the paradigm that children are actually victims of this abuse, because what's going on in the home is a psychological maltreatment that is not, they're unacknowledged victims. And this psychological maltreatment is not something that CPS picks up on. It's something that courts totally disregard. And so how do we even quantify that when we can't even put an assessment on whether or not a child is being psychologically abused? And if a child is, and I will stop in a moment, but if a child is also aligned with an abuser. So when we talk about the experiences of children in these homes, it is not always overt, and it is not always something that is, again, it's very hidden. And we know that creates the most complex post-traumatic stress. We know that with adult victims, that the most complex post-trauma stress disorder is related to the hidden abuses. And so with children who in fact may not even know they are victims of abuse, they don't even know it, or their adult protective parent doesn't even realize it's going on in the home, that in fact seems to me to be the most egregious type of abuse. And it's the one that is unacknowledged so significantly. So that's
Before we turn to Maisha, do you have a citation you might be able to provide for the research at 90%? I think that's
Sharps, Jeffs, and Kelly did that research. I'm not recollecting the year, but it's not very old. It might be 2015 or 2016.
Sharps, say it one more time for
Sharps,
anyone.
Jeffs, and Kelly.
Okay, great. Thank you. And Maisha, your thoughts on these, and I'd love for you to weigh in. You mentioned earlier when we were talking the cultural perspective, how that plays into it.
Well, one of the things that I wanted to assert in what we were already talking about is the response by the courts. So most courts, I've practiced in several different jurisdictions. At the core of what a judge is looking at is what is in the best interest of a child. So that's the standard of care that they want to identify in either parent, and to make sure that that's promoted. One of the things that as a policy that exists in the law is that courts should try to include both parents in the child's life. So when they make an outcome, whether it be a court order, temporary or final, they're motivated by what the policy says is the best practice, which is that both parents should be involved in the child's life. And the problem that fundamental policy position doesn't allow for the court to have a perspective when there is this dynamic of coercive control being introduced, is that their viewpoint is to try to remain unbiased and not be persuaded that there is going to be a parent that would do something that would make it difficult for both parents to have the opportunity to share custody, to share access and possession, and be around a child. And that is flawed. And that in and of itself assists in allowing these cases to be prolonged and allow for the high conflict dynamics that I'm sure we're going to get into as we proceed with the conversation. The other thing, as it relates to cultures, there are certain cultures where the issue of, so for example, African-American women in these types of situations are oftentimes perceived by the court as being the dominant parent based on stereotypes, based on very unfortunate tropes that exist in society. And those things are exploited oftentimes in certain cases that allow the person who is in fact the non-protective parent to be able to prevail, not because there is substantial evidence to support those claims, but there is a perception that has been exploited by stereotypes and biases that unfortunately leave someone very vulnerable to being perceived in this system. And so those are things that we, again, need to be very cognizant of, because those are some of the things that allow these cases to fester and to devolve in ways that doesn't really get to the truth, which is what you're supposed to be pursuing in the judicial system, and allow for you to have sufficient evidence to make clear judgments about what is in fact in the best interest of the children that you are hopefully trying to protect as you weigh the facts that are being presented to you.
I'm going to want to come back to you maybe on the culture piece, but I am curious, and I'm glad you brought up all of those points. But to follow up on two in particular, many children, it's, you know, we've all heard this, you know, even before anybody was probably involved in domestic violence, is that children do want to see parents even who abuse them.
Sure,
they feel a
that's
connection
true
to them. But in your opinion, how should those cases be handled when there is this kind of, you know, either policy or inclination to try to give 50-50 custody or?
So the court should be reliant on certain resources that are available. Many jurisdictions have the opportunity for custody evaluations. There is opportunity for experts to weigh in and assess the situation by doing studies, interviews, interacting with not just the parents involved, but collateral. So whether it be schools, people who may not have a dog in the fight, that are neutral in their ability to assess the circumstances of a child, to assess whether or not a child is being impacted by the divorce, and what do those impacts look like? How is this child behaving in school? How is this child interacting in social circumstances? And I think that opportunity does not get utilized. It's underutilized in many jurisdictions. Unfortunately, I think that it is incumbent upon my peers in the bar to who are representing parties to be trauma informed and to have a scope of understanding about how they can best help to support the outcomes, so that again they are children centered in what we want to happen. Obviously, we have an adversarial system. So the attorneys that are involved in these cases are representing one party or the other. But typically, there are some ways for them to, if the rules were defined in a way that, again, is victim-centered, would allow them to use resources and effectively find answers about impact on children that go underutilized. And sometimes, again, it's about resources and what the parties can afford to do, but it's also about whether or not the practitioners are prioritizing, at the end of the day, the most vulnerable parties in these cases.
We're going to talk. It's really important to talk about the various impact, the overall impact, the various effects, exposure to domestic violence. But we're talking about the family court system here, the effects that it has on children to be party to this kind of tug of war, for lack of a better word, during the proceedings that can last as long as a decade. And I know in your case, Tina, it did last a decade. But it seems to me that, a decade is kind of, it isn't unusual. And I just wanted to know, is that true? But also, if you would speak to each of you, how you feel about like whether what should be done in cases where the child does want to see whichever parent is suspected or alleged to have been abusive or is unstable. Tina, I'd love to maybe start with you because, and you also have a situation, you also grew up in a situation where it was a bit of the reverse of what you found in your marriage, your first marriage.
Yes. So I was raised by my dad, who happened to be the healthier of the two parents. In the system that I work in today, it's not the norm. I tend to have a lot of clients who are women, and research shows that they are typically the ones who are, it's an uneven playing field financially and in a lot of situations. So I have a unique perspective in that I was raised by my dad, and I'm grateful for that. But, I do see that the courts there's a lack of professionals who are trauma informed across the board. And for example, I had 2 child custody evaluations. Same situation, same case, same dynamics. However, they were night and day different. And a lot of that. So I often say, it's like the wild, wild west, whether you're in front of a judge, 2 different judges, 2 different outcomes, 2 different child custody evaluators, depending on their training and knowledge and biases and all of these things. There's no regulation, there's no oversight. And I called the first 2 years in family court. When you're asking about 10 years, is that normal? Sometimes it's longer. It's truly dependent on the age of the child when you start. And so many parents that I know have countdowns on their phones waiting until their child ages out of the system, because this post-separation abuse doesn't stop until your child ages out. And there's really nothing final in family court. Even if you have final custody orders, if your child is 16, I've been to court 6 times since my final custody orders. So the children are weaponized, and it's a very difficult dynamic. But I consider the first 2 years of a family court case to almost be a grace period, where the courts and the professionals just expect and allow for a certain level of conflict. And it's only at that 2-year mark that they start leaning in a little closer and wondering why you're still there. And so that first 2 years is incredibly painful, because in a lot of ways it's wasted time.
Katie, can you talk about some of the effects on children of this process that Tina just described and that we're talking about here?
Sure. And there's a whole bunch. I think when we're really talking about the health implications for children, it really results in children growing up in an environment of toxic stress. So a child can very much love a parent that's abusive and also be scared at them. And I think the courts and really in society in general, we don't do a great job recognizing that these 2 things can coexist, like a love for an abusive parent and also fear. But when a child lives in an environment where there is a lot of toxic stress, it really has profound implications for their brain development, for their physical health. The Center for the Developing Child at Harvard University has done a lot. There's great podcasts and videos for people who want to know more to understand how toxic stress impacts the developing child's body. And really, that's what it comes down to, these prolonged cases where kids are living in these environments where what they say is being monitored, where they can see the stress that their healthy parent is having to endure to try to protect them and keep them safe. It really has huge implications for kids. And I think the court system needs to do a better job of recognizing it. And then, all of us healthcare professionals, court professionals need to do a better job of protecting children, recognizing these things and doing what we can in terms of like primary, secondary, and tertiary prevention, because secondary and tertiary prevention for this generation is primary prevention for the next generation, because we know that family violence is transmitted intergenerationally.
Mhm. I'm so glad you mentioned the Harvard Center for the Developing Child. I don't remember the name of the center, but I think it's important for any of our viewers to know also that Dr. Nadine Burke-Harris, who did a great book on former California Surgeon General, did a great book called The Deepest Well, that really showed the physical as well as mental effects of growing up like this. Anybody else? I think it's so important to focus on children. So Christine, please weigh in on like what you know about the effects on children.
Sure. So I think what's really important for people to recognize is that there are some studies that talk about that psychological maltreatment, that hidden abuse that's unacknowledged. And when we think about adult victims who live in these homes, they learn readily to regulate their behavior. They learn to, we call it walking on eggshells, right? So they're constantly regulating their behavior. We know they have significant anxiety. We know oftentimes suffering from depression, and there's other manifestations of their trauma. And what research is showing us is that children actually have the same identical manifestations. And so these are children who have difficulty with self-sufficiency, because when you are constantly trapped, and you don't know you're trapped, right? So you are regulating your behavior constantly. You're not able to make decisions that are best for yourself, whether it's just, perhaps these are children who have difficulty with something as simple as walking into a birthday party alone. At the age of 8, 10, 12, 15, we see this across the lifespan with these children into adulthood. Significant anxiety. That self-sufficiency, again, is a huge issue. And it really comes from having one parent having power and control over another parent. And when kids see one parent, the victim, regulating herself, they also begin to recognize that, is it a good time to go downstairs and turn on the TV? Or should I ask dad? Let's assume dad is the perpetrator. Should I ask dad if I can go over to my friend's house now, or should I wait until later? And so again, very much regulating their behavior similarly to how an adult victim would do. And then they watch so they're role modeling this too, because even if we were to take away the abuse, if the adult victim is constantly regulating her behavior, she's actually role modeling for her children that regulation. And so what does that do? That is consistently creating the amygdala firing up, cortisol levels being, as we know with trauma, all of these impacts that create dysregulation. And I think that one of the things that I hear over and over again from the protective moms that I work with is that these children are very dysregulated. They're very dysregulated. These are kids who tend to be very angry. They are children who tend to it could be avoidant too, but they tend to really have a lot of difficulty regulating their emotions. And again, very much like adult victims.
Mhm.
When we talk about like when adult victims go into court, right? And where their trauma is manifested in court in such a way that makes it difficult for, I would say, patriarchal norms to actually accept, right? Because the court system is set up in a way that we don't look at victims through a different lens. We look at victims through the patriarchal lens, and that patriarchal lens says that people are supposed to behave a certain way when they come into our courtroom. And so there's no dispensation for someone who suffered significant trauma. Then let's add in that the trauma is invisible to most people. Let's add in that the court system doesn't see it as abuse. Let's add in that we have children who maybe at home are giving us really great, like, for lack of a better word, difficulty. They're difficult to handle. And so then people are saying, well, then it must be your fault because they're difficult with you when they're with you, but they're great with this other person who, by the way, is the abuser. But what do children learn? They learn that the best way to behave is to behave in alliance with someone who feels safer. It feels safer to align with that person, because if I don't align with him, he's going to do the same thing to me that he does to my mother.
It seems to me what you're describing, Christine, does is one of the big factors that leads to the cyclical nature of this. If a young woman or a young man grows up watching a mother or a father, just take all sorts of emotional or, and God forbid, physical abuse, it normalizes it, and then that might make them more apt to end up in a relationship that could be violent or otherwise abusive.
Sure, but I do feel the need to say that victims never take this abuse, and that this abuse is inflicted upon them, and we have to be, I mean, I'm not suggesting you're doing this, Jane, but in general, it's just so important that we never assume that a victim has taken abuse, right? And that actually the system is set up, whether it's the systems of the court, or it's the systems of the police, or it's the intimate relationships that are related to gender oppression that create this type of abuse and relationships, and that it's inflicted by only one person. A person makes a choice to do that. So.
No, that's a very important a way to address it. Anyone else, and any examples, whether it's the kinds of things you've seen that could kind of paint a picture, like the effects on children?
Yeah, I remember when my daughters were young and they would come home, and like Christine talked about, they're almost, I used to call it, they're like little pressure cookers. They've had to regulate at an age where they shouldn't, that's not what they should be worried about. It wasn't a safe environment for them to emote or for them to express their opinions or feelings on anything. And so
is this when they are coming back from perhaps visitation?
When they would come back from their abuser, from our abuser's home.
Yeah.
And so, when they would come home to me, I almost didn't recognize my child, because, they have bottled everything up for days, and they finally feel safe. And so you're on this continuous cycle and roller coaster. By the time you finally get them regulated, it's time to go back again. And so they never have a sense of normalcy. And it's truly horrific to watch, but so much of it, I remember one time my therapist said to me, you need to work on your anxiety, because if it's coming through, you're going to be blamed for why they don't want to go to the other parent's house. And so it was on me to get myself centered, so that, it's such a difficult situation, and so much of it is invisible. How do you document that? How do you really paint a picture for the court? Because it's not the bruises, it's not the physical injuries.
Can I say something about documenting what Tina's talking about? So there's a couple of things that have come to mind as we're talking. One is that there is a lack of expertise in education as it relates to those who are in positions of authority to be able to make decisions about what is happening in these courts, right? So judges, I'll speak to my jurisdiction in Texas, have to have 4 hours of DV training. That is not enough time. It's insufficient to be able to talk about the things that we were talking about. So the deregulation issues that Christine is describing, what Tina is talking about in terms of how do you get that evidence in front of a judge so that they have an understanding about what is actually happening outside of the courtroom. Attorneys don't necessarily, again, have the requirement to take specific training. So a lot of people who are in these systems are not educated enough to be able to produce a presentation to a court that would allow the judge to be able to get educated and then make decisions based on, again, the facts, the evidence, and the expertise. One of the things that we should be doing is requiring more education on the part of those who are going to make these decisions. So judges need to be educated, and the minimum standards need to be increased across jurisdictions. The other thing is that attorneys need to be trauma informed if they're going to take these types of cases. There needs to be experts who are utilized in these courts. So one of the things that we try to do at my organization is rely on expertise and experts who have the ability to give the court something to examine in a way that allow them to be able to appreciate some of the things that we know to be true For example, when a brain is impacted by trauma, there are certain things that happen physiologically, right? And it manifests in multiple ways. One of the things that might happen is that someone who is traumatized doesn't have the capacity to tell a sequential story. And they may, sound less credible than someone who's manipulative and who has the ability to be coherent in a stressful situation. And so those things factor into outcomes in the system. And it's not because the judges want to make the wrong call. They want to do what's right, but because they're not equipped, the system is not holding people to a standard of care that is higher so that we can get better outcomes. And we can get closer to the right thing to do for a particular situation. And that requires advocacy, requires lots of things that don't necessarily come to fruition because of the way that we have relied on our system and unfortunately believe that the system is fair and just. We all start with the premise that if I'm going to go to court, that person, the judge, has this sort of innate ability to know what's right and wrong, to be able to, they're sort of the Wizard of Oz, it's like the all-knowing, the all-powerful, the all-seeing, and that's really not true. But
Maisha, you mentioned in your state, 4 hours of training is required, and that isn't enough. But isn't that, I don't know if this is a Katie question, but isn't that more than in many states? I mean, aren't
I'm not sure. I couldn't speak to from jurisdiction to jurisdiction. Maybe Katie does have the answer to that.
Yeah,
I can talk some about that. I mean, there are some states that have no requirements and really no regulation about what type of training is needed. So I'm in Baltimore, I'm in Maryland, and we just passed the first judicial training bill in the entire country that requires, and it's only 20 hours of training. So it's like a teensy tiny first step, but it's on ACEs and it's
but
about—
it was fought a lot, right? There was
it was fought. Yeah. I mean, it was a big fight, but it got through and it's really great. It's still only 20 hours of training, which is a start. But one thing, and I would like to mention this, I was thinking about this when you were saying, Maisha, is that research on custody outcomes, the little that there is, a lot of times, even when there are documented and criminal convictions of domestic violence, that doesn't make it into the trial court records. So research by Hardesty and Olgusty and colleagues, more recently, they just published something this year that demonstrated that. And then there's an older publication from like the mid 2000s by Kernick et al. Called Children in the Crossfire. And I think one thing that we really need more attention on is how our court gatekeepers sort of like obfuscating abuse in terms of like what is and what isn't making it into the trial record. And that's really important because, when you have custody outcomes and they're documented in criminal convictions of domestic violence and it's not making it into custody outcomes, you're not going to have a decision. A judge can't make the decision that's in the best interest of the child because they don't have all the information.
I wanted to mention to the viewers that we are going to start addressing some of the questions that are in the Q&A box, but some of them do fortunately overlap with what I was going to ask and what we've discussed already. One did speak to the training and what kind of training they have, but someone was asking a question that I wanted to ask a version of it anyway. So it goes back to this idea that she's, sometimes if you're going to experience this kind of abuse because you've separated and perhaps put your child into harm's way, that would seem one of the factors is there lethal danger? What are the indicators that there could be lethal danger, and what do our viewers and others need to know about whether it's better to leave or to stay and protect your children?
I can talk about lethality.
Katie, please go ahead.
So I work with Dr. Jackie Campbell, who created the danger assessment. And so I think what's really important is, we're talking about post-separation abuse, and I think we have to talk about the risk of intimate partner homicide. This is something that's very gendered. So for example, half of women murdered are murdered by an intimate partner. And about half of those happen around the time of separation. So the first 3 months followed by the first year, those are the most dangerous times. This is, like I mentioned,
aren't the numbers, that's been quantified, the number of children killed during custody disputes, and it's got to be well over 800 by now, isn't it?
So the Center for, and I'm actually doing some research for the Center for Judicial Excellence. So hopefully we'll have a publication on that, hopefully soon in the next year, but we're looking at that. I think their number is up to 868, I think now, I'm ballpark. And when you look at the National Violence Death Reporting System, they've identified that about 20% of child homicides are related to intimate partner violence. And child homicide is the 4th leading cause of death in the United States, and firearms are the leading cause of death. And so when you talk about the combination of separation, family court, firearms, it's lethal. I do want to say intimate partner homicide and child homicide, they still are very rare events. But there are, if someone is trying to leave, I would definitely encourage them to use, to talk to an advocate and make a safety plan. That's really, really important. There are also, there's an app, it's My Plan Safety app. It was developed out of research by researchers out of Johns Hopkins. The danger assessment is actually embedded in that. But things like,
if you could repeat that.
oh, sorry, I'm talking fast. I'm like, there's so much information. My Plan, myplan.org. And Nancy Glass, Dr. Jackie Campbell are the creators of it. And it's, individuals can use it to safety plan. And they can also, it's got the danger assessment, and they can kind of like prioritize what's important to them. So that's something that's really great. You can get it on your phone, or you can use it online. But when we're thinking about lethality and sort of like what are some of the signs, firearm ownership and access, strangulation, that's often called the last warning shot. So if you are with someone or have been with someone who strangled you, that is a very dangerous person. It's really important to talk to an advocate and make a safety plan. Again, sorry, I'm just getting over a cold, so I'm losing my voice. And I mentioned separation. About half of femicides were precipitated by separation. And if there is a highly controlling perpetrator and separation, that increases the risk by 9-fold. So this is very dangerous. And then threats to kill, threats to harm children, and threats of suicide. It's an older study now, but it was based on the National Violent Death Reporting System. I forget how many states were included in it, maybe 16. And it looked at male perpetrated homicide suicides. Almost all homicide suicides are male perpetrated. It's very rare that it's female perpetrated, but 57% of those homicide suicides had family court involvement. And that is why it is so important for us to look at the intersection of domestic violence and family court, and to make sure
we have
safety plans.
Okay, great. Thank you so much. We have about 7 minutes to go before we're going to open it up to the questions from the audience. So I want to be sure that we hear from everybody on what are the solutions. To me, as a journalist who was looking into and still hopes to do something on the Maryland legislation turned law, that seems to be one of the basic policies that would be important across the country to address this. So to educate judges on what the effects are on children. But maybe starting with you, Tina, what do you most want people, lawmakers, the general public, and others to know, and what are the solutions?
I think that something that should be on everyone's radar is that whenever judicial training is proposed, the organization supporting family court professionals come out with guns blazing. They don't want additional education to be, additional trainings to be put on. They say they're overworked already. We already get education. and they're not getting the right type of whatever is happening. And you mentioned judicial education before. Here in California, it's a recommendation that within the first year of the bench, they receive, I believe, 5 hours of training, but it's just a recommendation, and they can be on the bench for 12 months with 0 training. That is unbelievable. And it should have everybody, up in arms, because this, in my opinion, is one of the most important branches of our judicial system. This is literally holding the most vulnerable members of our society in its hands. And I think there's a lack of regulation and oversight in family court. I would like to see cameras in every courthouse and open access. I sit on court calls a lot and as an observer, and it's very rare to even be able to watch online, and even walking in some states, you can't observe. And so I think for accountability reasons, we should have cameras in every court across the country. I think people would sit up a little bit straighter.
Serious privacy concerns related to, what could become known about what the child's been through?
I think that in those situations, we already have, they will ask people to leave the courtroom if we're talking about child sexual abuse or things like that. So, with exceptions, obviously, but in general terms, I think you would see family court professionals who are acting a little bit better. I mean, I often say the abuse I suffered from family court professionals in a lot of ways was worse than what I suffered during my marriage.
Just to clarify before I go to Maisha for some of her final thoughts before I start, I'm actually taking the questions from the Q&A. So when I say take the questions from the audience, I'll be reading some of them. But Maisha, what do you think is most important? What do you most want judges, lawmakers, the general public to know about this issue, and especially on how to solve it?
I want people to understand that the access to the courts and the continuation of abuse is real, and that there are so many obligations that are put on the shoulders of the people who are victims in ways that are insurmountable. And so we really do need to look at this as a societal issue. And I'm completely in agreement with Tina that there should be substantial efforts on the part of all jurisdictions to expose the level of care that we provide as a judiciary and as it relates to family cases. Most people in their lifetime will know someone who has gone to divorce court as opposed to criminal court. But what we see in the media and what we see oftentimes in the public sphere is all about criminal law. And this space is avoidant of eyes that will allow us to expose many of the deficiencies that exist in the system. Some of the things that I recommend people do in your local jurisdictions is to devise court watches. So where you have courts that are open, groups that are willing to go in and develop court watch programs so that you can hold people to a standard of care. Those things are things that you can learn to do without a lot of economic requirements. It can be done by citizens who are just interested. We've had court watches in Harris County courts that are comprised of volunteers, people of all different professions, but they are interested and like-minded in elevating the standard of care for the judiciary as it relates to family courts. So those are the types of small recommendations that I think would be helpful. I am still going to bang my drum as it relates to education on the part of the judges, as well as, again, my peers in the bar. Attorneys who practice in family court, I think, have an ethical obligation to become educated and to be trauma informed as they engage in these particular types of cases. If you don't have that expertise, refer the cases. Do not take these cases on and put people in further harm's way. It's just wrong.
Christine, please do weigh in.
So I concur with everything everyone is saying. The one thing that the caveat that I would add into this is that what is that training? And so I think that if we do not begin talking about the pathology of most abusers, so again, I'm not talking about situational violence, I'm talking about coercive control. There is a certain type, there is a certain pathology. And so we can educate people all day long about domestic abuse, but if we don't talk with them about who these abusers are and how they very readily appear as well-adjusted, and they very readily appear as, well, they're charlatans. So they come into the courtroom and they're able to perform, they're performatory, and they trick, they fool everyone. They fool therapists over and over again. I'm a social worker. They fool therapists all the time. My therapist didn't recognize what was going on with me. They certainly fool all the court professionals. I don't want to say all of them, meaning professionals who work in court. It doesn't matter what you do. There are people who are fooled along the way. And so how do we create education that actually addresses this very significant shortcoming that puts children over and over again in harm's way with abusers, never mind adult victims? So that's where I'm coming from.
Thank you. And Katie, turning to you before I open it to my asking of the questions in the Q&A box.
Yeah, I would absolutely agree with everything that Maisha and Christine and Tina have said. Training in and of itself without accountability is probably insufficient. And the other thing is that framework matters. And so if judges are viewing things from the wrong lens, they're not going to see what's right in front of them. And I think that's really important too, because if the predominant narrative in family court is these are parents that just can't get along, and this is high conflict, they're going to miss the abuse that's right there. And one of the things that I argue is that I think, judges, family court professionals, they can identify the different, they can differentiate between situational violence and post-separation abuse and intimate terrorism by looking at the broad pattern of tactics that a perpetrator uses to really target the fundamental human needs of someone, right? Are they losing their shelter? Can they not afford food? Are they losing custody of their kids? Who really has the sort of power and control, and how are they using it? And what are the consequences to the children? And I think kind of reframing the lens is something that really needs to happen.
Thank you so much. One of the questioners, apparently there's a big contingency from Massachusetts on this call, and they would like to change the law up there around coercive control, and they're wondering what tips, guidance, advice would you folks give to make sure that they're most successful? That sounds like I should volley that to you, Christine. How would you like to advise the folks in Massachusetts who want
Sure. I think in
to
Massachusetts,
expand
also,
the legal definition up there?
yeah, and I think Massachusetts is one of the few states also that's trying to also include the Phoenix Act, which would expand the ability for domestic violence victims to actually be able to come forward and hold abusers accountable. And that's Evan Rachel Wood's piece of legislation. So I would say anybody in Massachusetts, since you're so close by, but anywhere in the country, people want to reach out to Connecticut Protective Moms. Connecticut has one of the strictest or stringent pieces of legislation. So does Washington State. But Connecticut.
And there's a website for that, Connecticut Protective Moms.
Yeah,
I believe very active on Facebook as well. Is that correct?
I think so, yes.
Okay, yeah.
So what I would say is that it's important to reach out to your legislators and any legislator who you think may support this piece of legislation. It sounds silly, it sounds mundane, but we really do need to activate legislators and let them know how important this is, because the more people they hear from, the more they're going to be willing to change it. I do know that there's been something on the table in Massachusetts. I'm not sure where it stands right now, but I assume that something has to be done by December 31st when they go on break. So if not, then in the new year. But certainly we have a policy brief and we have a guide on Connecticut protective moms that I created. And if people are looking to have something similar for their state, I'm happy to work on that and support you in that process.
I know there's at least one question. Well, certainly one question. Somebody wanted you, Katie, and Christine to do a similar webinar for their law firm. So you might want to look in the Q&A box and answer that one because it's a little specific. But there will be the folks that organize this, the Family Court Awareness Month people will be following up with people for the questions that we don't get to. Somebody, I just want to quickly mention, somebody asked why there aren't more Netflix specials if millions of children are affected. I want to answer that just real quickly. I mean, I can't speak for Netflix, but this is a very difficult issue to get story articles published. The media, I know of many cases. I did several stories, one big story at USA Today when I left USA Today in March of 2021. I left one behind for a colleague who still hasn't gotten to it, because there is this tendency when the perpetrators or whatever, if you're thinking of a court system or many parents or many judges, when it's so amorphous, it's very difficult to kind of do a story that explains the trends. And there's just so much news these days. It's hard to get editors, producers to focus on it. It also is one that gets lawyers, media lawyers, pretty nervous. And I need only point to the Johnny Depp case to underscore that. Tina, did you have something to say?
Yeah, I just wanted to add the National Safe Parents Organization. It's nationalsafeparents.org. This year with VAWA passed Caden's Law, and now the efforts are to get Caden's Law implemented in all 50 states. We have the guidance and expertise leaning on Danielle Pollock and Joan Meyer of the National Family Violence Law Center. And so I really encourage everyone, if you are interested in legislative change in your state, join National Safe Parents Organization and connect with others in your state within that community, because there's probably already efforts underway in your state and we need everyone on deck.
Can we, the website for safety planning is, I believe is an app. Somebody asked about that. It's an app called My Plan. Is that correct?
Yeah, it's My Plan app, app. So myplanapp.org.
Oh, okay. I thought it was just an app. Okay. myplanapp.org.
It's also available in the app, in your app store.
And it's also in your app store. How somebody asked, is there a way, her name is Jamie, or their name is Jamie. Is there a way to navigate the system in a better way? It feels like victims are forced to try to protect their children and not do so much that the court takes away the children because they're alienating them. I mean, we could, and I think there might be a whole session related more towards that. But is there, could Maisha or Katie weigh in on kind of how to balance that so that you do what you're supposed to do without getting accused of alienation? Katie?
Yeah, that's a great question. It's
Maisha,
the answer. Sure. Great question, hard answer. Again, because there's so much variation in jurisdiction, I can't speak to all of the elements around access and what you are supposed to do. Generally speaking, though, when you are in these types of cases, there are rules of engagement. So you're going to have hopefully representation. You will have the codes of the different jurisdictions that govern how things are supposed to go in terms of what is supposed to be filed, when those things are supposed to occur, and being compliant with that process can be effective in allowing you to navigate through the system. of course, what we're talking about is deficiencies in the system. And unfortunately, the system is led by people who have, agendas that don't necessarily line up with getting to the truth, being fair and balanced, and hopefully, again, advocating for the most vulnerable in these situations, which ultimately are the children that people in these high conflict relationships share. So it is important to find the right advocates. It's important to, when you're engaged, always be safety planning. It is not just something that is limited to I'm leaving, I filed. There should be a continuum of care around safety, because again, the system is set up in such a way that it is adversarial. And sometimes what is going to factor in is that you have opportunity to continue the fight. And we get caught up in that. And sometimes that in and of itself, and this is true for the protective parent as well as the one who's the perpetrator, in terms of your level of engagement at some point needs to be reconciled with what might be, you should be limiting your time in this system if you can, when you can. But of course, be prepared for a long fight and recognize that it could, again, without any effort on the part of the person who's trying to just navigate and get a good outcome for their children, be something that continues on because of the nature of the person that you are going against, right? So again, that's what you need to be mindful of. Don't get caught up when you can avoid getting caught up in that trap that sometimes is there.
Somebody wanted you, Maisha, to put something you said about 11 minutes ago in an open letter, but we'll get to that later. They liked it so much. There are so many questions, and I know that the family court folks are Family Court Awareness Month folks do plan to get back to everybody. But I want to let's perhaps end. We are ending in 3 minutes by talking about the various kinds of abuse that include financial abuse and just how costly this process is. So it's not only painful, emotional, and mental health challenging, but it costs so much money. Christine and Katie, if you would weigh in on thoughts on the financial abuse and how women can keep themselves, quote unquote, safe from that and other kinds of abuse that's not physical.
Well, I would say that we know that 99% of victims of domestic abuse suffer financial abuse. So it's really hard to talk about safety around that. It's really hard. I think it becomes a very difficult choice. Do you walk away from everything? Because walking away may actually diffuse the power and control a person has over you. And walking away means that you're starting over, that you might be filing bankruptcy, that devastating. I think pretty devastating. And certainly depending on, we haven't even really talked about people who are living in impoverished situations, right? And how domestic abuse literally decimates them and they don't have a lot of primary support. So I would just say that it's something that we know virtually every single victim experiences. And if they haven't experienced it directly, they are experiencing it through the vexatious litigation that incurs.
And Tina, I did want to go to you, and we might only have time for you to kind of sum up on that point, please.
I always say when you're dealing with this type of person on the other side of the equation, their number one button is typically the finance button, money, and so the harder that button is pushed, the more they retaliate when it comes to the children. And it's not fair, but so many of us have to make the very difficult decision. I know I did, to have to just completely start over from scratch. There's nothing just or fair about the family court system. For me, a huge part of that has been radical acceptance that the current day system, I'm not going to change it. And so radically accepting that this is how it is. And then I have, as we were talking about, choosing your battles wisely. You can get caught up in every battle and they throw them all out there to try to engage you. And so it is so important to take a step back and really, for me, it was lifting my vision and saying, is this going to matter in 2 years? And some of that financial, you can look at it that way too. Would my time be better spent rebuilding my career, putting myself back into school, or continuing to press this button for money? Again, we should be entitled to it, our fair portion, but unfortunately the kids suffer many times when we are going down that path. And so for me, I really walked away from all of it because, my kids were suffering so badly.
Mm-hmm. And we're going to end on that note. And I think, just to paraphrase what you just said, the kids are suffering. And I think that that's what's most important, if I might say that myself as the moderator, that children are suffering because of so many of these cases, and the fact that they're drawn on so long, and that the judges are not aware of the deep, lasting, and costly to our economy effects that this has on our children. Thank you all so much for joining us